Hi everyone, my name is Ruby Powers and I'm with Powers Law Group and we're talking about green cards for immediate relatives. I've been board certified with the State Bar of Texas and the law firm is 15 years old. I have a second book about law practice management now and I'm excited to present on this topic, which is not legal advice, but just general information. So what's an immediate relative? Well, this is a term that describes a spouse, an unmarried child under 21, and or parents of U.S. citizens. And the theory is that it's got a lot of different great benefits, but one of them is that the visa is immediately available. And so there's not the limits like there is on those who are, if you looked at the visa bulletin to see the waits times there. So they're able to bypass the visa bulletin, but there's also some other benefits when we're talking about adjustment of status. And so this is only for US citizens and not to legal permanent residents. The eligibility, so US citizen petitioner must file an I-130, so that's the petition for alien relative. And they have to prove that relationship. So you show that with marriage certificates, birth records, adoption decrees, or the like. They also must be admissible and shouldn't have a criminal record that will prevent them from being able to adjust unless they would, or to be able to consular process unless there's a waiver that they'd be qualified for. So a spouse of a U.S. citizen, you would need to, you can petition for your foreign national spouse and you need to show proof of the bona fide relationship, joint financial accounts, shared lease. They love taxes, they love leases, and as much evidence as possible. We've applied for people who just got married, but the more evidence you have, the better. In general, if the person is in the United States, the immigrant beneficiary, then we'd be doing an adjustment of status. But if they're outside of the country, we do consular processing. Now, one thing to note that's important to this is that if you need to be able to have been admitted, inspected, or paroled to do adjustment of status. So if you have not, then we might have to do a waiver and a whole different system. But you could still, if everything else qualified, we could still do the process. Now, children of U.S. citizen, it's important that they are under 21 and unmarried. Stepchildren still also work, but you just need to make sure that that step relationship was created before the child turned 18. Adopted children must be adopted before they turn 16 and meet other requirements. So you have to make sure that you do that regarding Hague or non-Hague country conditions. Now, parents of U.S. citizens, this is a little bit easier to understand because usually their name is on the birth certificate or you would have to show a DNA test, but ideally proof of that relationship. And if the parents were not married at the time, would have to show the proof of the relationship. And if the parent wasn't on the birth certificate, that can get a little bit more difficult, but there are ways to overcome. So the process is in generally you file the I-130 and the petition for alien relative, and once it's approved, if you're inside the United States, you don't need to wait for it to be approved. You could file the 485 concurrently. That means like at the same time. But if you're doing consular processing while the immigrant's outside, you would wait for its approval and then you would submit the DS-260 and then proceed from there. Now, those who are doing consular processing, once the I-130 is approved and you get pay the fee bills with National Visa Center, the DS-260 is very similar to the I-485. There's a lot of questions about where you've lived and worked and any problems with the law, just in general. And once that's submitted, then you'll be waiting. And the I-64, which is about financial support, you'll be waiting for the consulate embassy in BC to give you a guidance as to the next step, waiting for your appointment. But you don't leave, but you don't make any plans to travel to embassy or consulate until you are given that notification of the interview. Now, proof of the relationship, marriage or adoption or spouse or whatever the relationship it is, passport, copy, identification, there's a lot of different aspects that you need depending on whether you're doing adjustment of status or consular processing. And if you are doing consular processing, you generally need to show the police clearance letters for everywhere you've lived after the age of 18 for 6 months or more. Now, proving bona fide marriage, this is really a lot through, I'd say, third-party documents like taxes, bank accounts, leases, If you don't have a lot of that, then we get into like other things like affidavits. Photos can only help so much. Affidavit of support is used for whether you're doing adjustment of status or consular processing. This number usually changes every February, March of every year. And you can just look at USCIS I-864P, and that one will show you what the number is, but it's generally that you need to meet more than 125% of the federal poverty guidelines. If the petitioner doesn't meet it, then you would want to get a joint sponsor. Now, this is legally binding until the immigrant becomes a U.S. citizen, abandons the green card, passes away, or earns 40 quarters of work. Medical and security screening. This happens through medical exam with a U.S. civil surgeon if you're in the U.S., or an approved civil surgeon outside. You have to have the vaccinations that are required. You can also just Google USCIS vaccination requirements, and you can see the list that's required. And it's important to check all of that. Now, immediate relatives, this is one of the good things, is that they're exempt from the annual visa caps. If an immediate relative entered legally and they want to adjust status, if they don't have any other inadmissibilities that might require a waiver, they could potentially adjust status inside the country. But it's best to have a consultation to review this just to confirm everything is accurate, because there is the creation of unlawful presence back in April 1st, 1997. And if you entered and left and overstayed somewhere along there, you could have a bigger issue. But if you entered legally one time, overstayed, and have an immediate relative petition, then you generally could adjust status. But it's important to have this reviewed because it can easily get confusing. So if something is incomplete or they have more questions, they'll ask you for a request for evidence, asking for more information. And so it doesn't necessarily mean it's going to be denied, but it's best to put your best foot forward initially and get that information that's necessary. Now, if we're talking about a spouse petition, if the couple has been married less than 2 years at the time that the immigrant gets the green card, then they'll get the conditional green card. Otherwise, they'll get, which is only good for 2 years, in which you need to file a petition to remove the condition. But if you've been married more than 2 years at the time of adjudication, you'll get the 10-year green card. And the other thing to note is that of when you would be eligible for citizenship, based on marriage to a U.S. citizen, you can, and marriage and living with the U.S. citizen, you can apply no other problems and issues under the 3-year rule. Otherwise, it's the 5-year rule. So it's important to know this is just general information. Hopefully this was helpful. You can reach us at 713-589-2085. You can find us on TikTok, X, newsletter, and every other week in English and Spanish, Instagram, Facebook, a whole bunch of places. And we've also recorded this in Spanish as well. So we have a lot of different webinars this month. Next week, you're going to hear about what you need to know about the humanitarian parole process. So thanks so much for watching. Feel free to share with a friend and give us a call if you want a consultation. Thanks.